I'm glad you're joining us this evening here in PBS Fort Wayne for Life Ahead. If you've watched us regularly, you know that our show is intended to give you information and education to help you with choices or decisions you have to make in your life ahead. Well, maybe it's a legal thing that you have to deal with, and I have the guy here that can give you some guidance. His name is Bryan Nugen. Bryan, you're right here. Thank you for coming.
Thank you, Sandy. I appreciate it.
Bryan, if you watch us regularly, you've seen him just about every month for a number of years here.
That's right. Yep.
And Bryan, you specialize in elder law.
That's correct.
Okay. So now if you have some questions for Bryan, this is your opportunity to get some complimentary advice here. He loves to do that. The number is 969-4720. Is that right?
2720.
2720. And we have a phone operator in the control room that will answer and talk to you for a minute, take your question. And if you'll talk live to us right here on the air, that's wonderful, because then if Bryan needs to ask something back, you're right there on the phone. If not, you can leave your question and they'll get that out here to the studio to me and I'll ask Bryan for you. Meanwhile, Bryan, let's talk about probate tonight.
Yes, ma'am.
Okay. Well, let's start. I always like to start as simple as we can. Let's get a definition of probate, what it is, and why we even are talking about it.
So probate is a process whereby when one passes away, if they have a will, or even if they pass away without a will, if they have assets that are over a certain value, they haven't designated for someone to receive those when they pass, with a beneficiary designation or by use of a trust, there's a process whereby we open an estate with a court. There's an advertising that we do in the newspaper to tell the world this person passed away, and if you believe that they owed you money, you're able to file a claim in that estate. The court appoints someone called a personal representative to administer the estate and to make sure that those debts that are appropriate are satisfied, and to distribute assets to those individuals that should be getting them through either who the deceased designated in their will, their last will and testament, or through intestate succession if the person didn't have their will. So that process itself is called probate, and we have court involvement and filings, and that process can, it's not hard for it to take a year.
Wow, seriously?
It does, yes. And sometimes if there's disputes in families or arguments that are going on, it could take longer. And sometimes there are assets that are a little bit more complicated. Maybe there's real estate that's a little tougher to sell. We're struggling to liquidate an asset. Sometimes that stretches out that probate process as well.
Does everybody have to go through probate?
You only have to go through probate if you have assets that are that don't have a beneficiary on them, that aren't jointly owned with someone else above a certain dollar amount, then you have to go through probate.
Not designated for a certain person or for a certain, or in a trust or whatever. And then who makes the final decision?
On where it goes?
Yeah.
Well, hopefully the individual's prepared something called a last will and testament. If they have prepared a will, we follow the terms of that will for those assets that don't have beneficiaries on them, that aren't jointly owned, that are outside of a trust. The will itself designates where those assets go. If we don't prepare a will, then there's something called intestate succession. So I died without a will, I died intestate. And if that's the case, there's a statute. Every state has a statute that indicates where funds are distributed should someone pass without a will. So for example, if I'm married, some may go to my spouse. If I have children, some to my children. It's possible actually for parents to receive as well through intestate succession.
Yeah.
So if we don't have something in place, the state, through its laws, determines where the money goes.
And you can't really change that. I mean,
you can't change that.
State list is what it is.
That's the list. That's the way that it is.
That's it.
You got it. And now the people that may be beneficiaries through that intestate succession statute, they could agree for it to be for us to have a deviation from what the statute states. But no, without folks agreeing to that deviation, we follow that list exactly.
What if there's disruption in the family? And you mentioned sometimes, there might be sibling rivalry, or somebody says, no, 5 years ago, my mom, our mom, promised I would get that. But if it's not in writing, what happens?
mom's promises, or sometimes people will say, I've put stickers on the bottom of things in my house and that's how things are to be distributed, or I promised my child they would get this or that, and the kids are relying on that. That doesn't have a lot of enforceability, no.
Okay.
If somebody relied on something to their detriment, maybe there's an argument that could be made that they're due that,
Yeah.
but generally no. Without it being in writing, the fact that mom promised something, it's unlikely that you're going to be receiving that.
You know, it seems like a modern trend because people seem to have so much stuff.
Yep.
Are you listening? I bet you do too. I think we spend half our life acquiring and the other half trying to get rid of what we've acquired. But anyway, it seems like a popular thing now is to have estate sales because so many people are working now. Maybe the kids are scattered out in different states, and it's just too hard to try to sell things or get rid of things one at a time.
Yep.
So they'll hire companies, and there are several of them here in Fort Wayne even, that will bring a crew in and go through your whole house, organize everything, put it out on display, price it.
Yeah.
How does that enter in?
Well, so somebody could take those items of personal property as their portion of the estate. So let's say that I'm sitting on this sofa and I want that sofa, but the mom's will didn't indicate that I was to receive that. I could take the value of the sofa as my portion. I'm supposed to get 50% of the estate. Oh. So some of my estate could be recognized that I'm receiving as the beneficiary. This sofa could be a part of that. But it's very common, actually, that as folks are aging, they assume that their children are going to want to have all of these items of personal property and so forth. But the children have already, they've purchased those items that they want. They have their home filled. So waiting until we pass to distribute those things isn't maybe as appreciated as it could be if the recipients were just a little bit younger. So I encourage folks to consider if there's something in your attic, if there's something in a closet that you aren't using, you're downsizing, to distribute those things so that you can enjoy other people using them. You can watch your children using them, and grandchildren using them, etc. But yes, there are times when we have assets in an estate that we need to dispose of, that no one that's able to inherit wants those items. So we will bring in companies like you're referencing that will indicate, they'll itemize each item, they'll take photographs of it. At the beginning of my career, we did live auctions where oftentimes you set up a tent in the front yard of the house so the individual that passed an estate auction in that sense. But we don't see that very often anymore. Typically, all of our auctioning for estates, for trusts, it's happening online. So those companies you're referring to, Sandy, they'll itemize everything, they'll publish them online, there'll be online bidding, etc. And that's how we dispose of those items. And frankly, I've been familiar with estates where people couldn't agree on the value of personal property. They couldn't agree how much something was worth. So how do we break that tie? Well, auction it. You can bid against the rest of the world, and whatever it is that value brings at the auction is what you're going to be paying for it. And sometimes folks are pleasantly surprised. It didn't bring as high of a bid as they thought it might, so they get that item for a lesser value. And but everybody in the family can be very comfortable knowing it truly was auctioned. That's the fair market value. That's what the marketplace was willing to pay for it. So it was sold appropriately. But yes, those companies are used on a regular basis.
And I know that they're very knowledgeable and qualified to do the pricing. But if they aren't sure about something, especially if it's like a collector item or a piece of art or something, they have resources where they can go to get a professional quote for what that might be.
Yeah, I've had art appraised in Chicago. I've had art appraised in Florida. So for sure, we use appraisers to do that on a regular basis.
We have a caller.
Okay, great.
Edwin is watching us here this evening. Edwin, thank you so much for watching Life Ahead. And you have a question for our guest this evening, for Bryan Nugen?
Yes.
Hi, Bryan. Or no, you're
Edwin.
Bryan. It's
Hi,
Edwin.
Go ahead.
Okay. I have some money coming, and I'm going to leave it in interest-bearing accounts. It's high interest on it. Can I when I die, can I will this money to my kids and put them on a budget You're not very good with money.
So Edwin,
It'll
that's
last several years.
Yep, that's a great question. You sure can put your kids on a budget. We don't call it that. If you want to control something after you pass, we typically use something called a trust. So you could say, I'm going to put this money that you're receiving into a trust. And I like to say to folks, whatever you can dream up, your attorney can put that in writing for you.
And you could do a trust then for each, if he has more than one child, for each of the children.
Yes.
Okay.
So I could do an individual trust for each child, and I could say the child is to receive a certain percentage of that amount every year. I could say that the child or children are supposed to receive a certain dollar amount every year. I could indicate that the money is available to them if they need it and they demonstrate a need. However, they can't just get the money outright, perhaps until certain ages. So we might do a distribution at age 35, 45, 55. I've seen instances where, as you're referencing, Edwin, folks are concerned that if I give them money, if I give my kids money, it will be spent very quickly. So they'll hold the money, they'll allow it to grow during the child's lifetime, and they may give it to them at a more mature age, 60, 65. The thought process is, if you get it a little bit later in life, I'm creating a retirement for you. And so that's growing over time, and you'll be able to enjoy that in retirement. You're also not inclined to not work because you think, oh, I've got some money coming, or I've got this money from Dad, so I don't need to work as hard. I've got that pile of cash sitting out there. So most definitely, Edwin, we can control how the money is used for your children or whoever else you want to remember by using trusts. So you would be the settlor, the grantor, the maker of that trust. We have someone that manages the money called a trustee. And then we have someone that's enjoying the money, the beneficiary. So in this instance, your children would be the beneficiary or beneficiaries. And whatever you can dream up, your attorney can help you reduce to writing and make sure that that money is controlled and money isn't spent foolishly. I think I'm using your words.
But it has to be a legal document for that to be.
Yeah, there's a whole, you couldn't, for example, to your point, Sandy, you couldn't put on a piece of lined paper, this is what I want to have done. It would need to be reduced to writing. It needs to be notarized. There are things that we want to have in that trust. So I would encourage you to speak with counsel and make sure that that's put in place appropriately, but most definitely you can achieve that.
And I'm assuming that you can do different amounts if you want, if you've got 3 children. It could be different. It could be different times that you give them access to those funds.
Yep. So sometimes what we'll see is if one child, maybe, we've helped them more during our lifetime. So at the time of our passing, we may think, I'm not going to give them an equal amount because I've already recognized them during my lifetime, and it wouldn't be fair for me then to divide everything equally at the time of my passing. You could, to Sandy's point, you could say, I'm going to give 10% of this money at a particular age, increase it by 25% at another age, 35% the remainder at a fourth date. So again, whatever it is that you think is appropriate, you're able to reduce that to writing in the form of a trust and take care of it. And I would encourage you, when you're working with counsel, let them help you or guide you to some different options that you may have. They may be able to come up with some options you didn't even consider. But thanks for the call, Edwin. I really appreciate it.
That was a good explanation, and I bet that happens a lot.
It does.
To people.
Yep.
Well, Edwin might have inspired Terry. He called in, and Terry, you have a conversation or a question for Bryan as well. What is that, Terry?
Yes, my sister-in-law was the executor of her mother's estate, and when she's the only daughter that lived here in the city. She had 2 sisters that lived out of the city. Well, when her mother died, she went to go, do what she's supposed to do. And here to come to find out, one of the sisters from out of town came in, unbeknown to anybody, and took her mom to a lawyer and got herself made the executor of the estate. Now, I was just wondering, is this legal? Or if it is, is there anything like, if their will's to be changed, the executor of the state should be notified that she's being replaced, because
Sure.
her mother was getting in the senile. She had the car taken away from her because she couldn't remember where it was and that, and I just didn't think that was right.
Well, you're on the edge of what my answer is going to be, which is what was her competency at the time that she signed the document?
Did she have dementia?
Well, there's something called testamentary capacity, which is sometimes a little confusing. So despite someone having a diagnosis of a dementia, it doesn't mean that they don't have testamentary capacity, that they can't sign a will. Assuming they understand who they are, they understand their objects of their bounty, who it is that's going to be receiving the money, generally their wealth and what's going on with that. In the moment, if they understand those things, and the attorney that's preparing the documents believes that they are competent at that time, they have that testamentary capacity, it would be okay for the client to sign. Now, if your mother-in-law didn't understand what she was signing, or somebody misled her into signing something and she didn't understand what was happening, that's a very different situation. So somebody wasn't being honest with her, somebody didn't explain the document she was signing, that causes some concern. You asked also in your question if the initial personal representative that was appointed in the will, if they have to be notified when there's a change in the position, and the answer is no. They don't have to be notified. So there was nothing that was done incorrectly by not notifying your wife. The question would be, was your mother-in-law competent? Did she have testamentary capacity at the time she was signing? And testamentary capacity is different than competency in general. Like, I may not be able to have competency to enter into a contract, but I have testamentary capacity to be able to put my estate planning documents in place. The courts want you to be able to determine who it is that's going to be handling things on your behalf. The courts want you to be able to determine where your wealth goes. Yeah. I would be more concerned if how the money is distributed is really radically different. If someone is serving as a personal representative in an estate and they're taking money or they're doing things that are inappropriate, you can always ask the court to remove their appointment as a personal representative. The question would be, in the will that your mother-in-law wrote, did she radically change how the money was being divided and maybe favor this sister-in-law that was from out of town? That might raise a red flag more so than somebody else being appointed as a personal representative.
Well, now you said that you have to determine whether they're what was the word you
testamentary
used?
Capacity.
Testamentary capacity.
Yep.
Does a doctor decide that, or how can you decide whether they are?
Normally, if there's a question regarding if someone does or does not have testamentary capacity, the attorney most likely will speak with the client, may have someone else accompany him or her to speak with the client, may speak with the client on more than one occasion to make sure that they're consistent with what they're saying, that they're consistent with what they want. If there is insecurity surrounding all of that, we can seek a doctor's letter or indication if the person has testamentary capacity. But we need to make sure that the doctor understands that we're looking at testamentary capacity, not capacity in a broader sense. So sometimes we do consult doctors, not always. It's not a bad thing to have a doctor's letter to indicate that someone has testamentary capacity, but it's not necessary. It's not a requirement to have that.
Got it. Okay. Well, we have another caller that's sending a question to us here, and this is from Sam, by the way. And here's the question for you, Bryan. He said, Sam said, my dad died 16 years ago, and he left me everything, but I haven't done anything about it. Did I wait too long? Or what steps should I take now?
Well, so Sam, thanks for the question. I do appreciate your calling in very much. It's not too long. Of course, we encourage folks to do that as quickly as possible after someone's passed. You have 3 years to probate a will. If you didn't probate the will, then we are going to go through intestate succession. But when you say he's left everything to you, I'm not sure if you're indicating that you were designated as a beneficiary on the accounts. If you were designated as a beneficiary on the accounts, by all means, go to the bank, go to the institution where those assets are, bring a death certificate of your father, and they'll give those assets to you. If your father's will indicates that you're to receive everything, then we may be a little late to probate that will. We'll have to go through something called intestate succession, but it's not too late for you to get some or all of the estate, depending upon if your father's married, if there are other siblings, etc. If there are other siblings, it may be too late for you to get 100% though.
You know, I can understand putting it off. I mean, it's a lot of work for, not for you, you know what you're talking about, but, you know, for the ordinary person, if you don't have legal background, you don't really know where to begin, and you just need to make sure that you get somebody that you trust. Larry had called in also, and he said, what are your thoughts, oh, I like this, what are your thoughts on AI-generated systems doing legal work on creating wills and trusts? I knew that would come along one of these days.
It's a great question, Larry. I think that we are starting to see AI do those things. I would be very hesitant to think that AI is to a point where it would be able to do all that work for you like a live, a person could do that's been in this for a period of time. It isn't always what you know, Larry, it's oftentimes what you don't know. So when you're speaking with an attorney, the attorney should be challenging you when you're thinking about, what if I do this, what if I do that? And the attorney would be able to speak with you about, there's nothing wrong with that, but you understand the consequence of that decision is A. But if you take this path, the consequence is B. Are we sure that we want to go towards A? Do you want to go toward B? So I can't say that I would be very comfortable advising someone to use AI to do their estate planning and preparing a will or preparing a trust. The documents may be fine, I don't know. I would be concerned about what you don't know to ask the AI to generate for you.
Right.
So
it might be a little early in the AI world.
Yeah.
I mean,
So
maybe in 5 years.
There may be a point where you actually, I spoke not too long ago to social workers, and this same question came up. And I understand that they're developing AI so that you can have counseling with AI. So I challenged the social workers in that presentation. So,
counselors,
counseling.
therapists?
They're talking about using AI for counseling. So what do you folks think about that as social workers? Do you think it would be appropriate for your clients to have counseling through AI? No, that's impossible. So you can understand in my discipline how I may also think that at least at this point, I don't know that it's far enough along. It may get there, but the question isn't how good will the document be, it's you have to put the right information in to get the information out that you need and to have the documents that you need.
And you have to have the education and the experience to know the possibilities.
Yep.
Right?
Exactly right.
Okay.
Yep.
All right. We're very short on time now, Brian, but if you want to speak very quickly about trusts.
Sure. Trusts. So one of our earlier callers, I don't forget, was Larry
I think
or
it was
Sam?
Edwin.
Edwin. So trusts, it's a written contract. It's nothing to be concerned about in particular. You've signed lots and lots of contracts in your lifetime. A trust has 3 different main parties in it. Trust maker, that's the settlor, the grantor, the person that has the money that asks for that trust to be written. We have someone called a trustee. That's the one that manages the assets inside of the trust. And then we have a beneficiary, lifetime beneficiary and ultimate beneficiary. So during the lifetime of the person that made the trust, who gets the money, an ultimate beneficiary who would get the money when the individual passes away. The thing that's nice about trusts is that it allows us to avoid that probate process that we were talking about at the top of the show. So that trust is like a giant beneficiary designation, and it indicates where the money goes, and if you want your money to be distributed at particular ages. If this child is passed, it goes to this child or this grandchild. The trust allows all of that to be written within that agreement, that contract. So a trust allows you to avoid the probate process, which we talked about earlier. It's not hard for it to be 1 year in length. There's some expense involved in that, of course, going through probate. It's public, right? I mean, anyone can take a look at your will. So trusts, it's like that beneficiary designation on your 401k, your IRA, but it's so much more than just a beneficiary designation.
I get it. And, there are many situations where you might find a trust the best way to go, especially, well, next time you come, we'll talk about this, for special needs or certain situations like that.
Special needs trust, there are any number of different types of trusts. Special needs trust, someone that is unable to manage their money, we want to protect their money, but it only benefits them. Special needs trusts are very important.
All right, well, see, you've heard it from the pro here. Thank you all for watching us here this evening on Life Ahead. And of course, we'll be back next Wednesday night with a new topic for you to discuss. That's Life Ahead, Wednesday nights at 7:30. Have a good night.
The preceding program on PBS Fort Wayne was made possible in part by
Nugen Law, focusing on estate planning and elder care law, emphasizing independence and quality of life. Serving Indiana, Ohio, Michigan, and Florida. More information at nugenlaw.com.